Mr.
My Lords, perhaps I can start by setting out the roadmap for the remainder of my submission.
Yes.
Within round one, I have 5 further points. First of all, I wish to return briefly to our trust analysis in light of your Lordship's comments. Secondly, I wish to return to our key point on loss. Thirdly, I wish to conclude my submissions on my learned friend's separate and distinct or single transaction point. Fourthly, I wish to return to Gwembe to make 2 additional points very briefly. And fifthly, the additional point as raised in the respondent's notice. And my Lords, I will then go on to deal with rounds 2 and 3. My Lords, first of all then, in terms of the trust analysis, and this arises, I'm revisiting this in light of your Lordship's various comments yesterday. Having considered the position overnight, and we've done some homework, I know my learned friends have done too, it seems to us that there are 2 main rival competing analyses, although ultimately for our purposes, the purposes of this appeal, they reach the same conclusion. So ultimately, it probably does not matter much which analysis is accepted. Indeed, for the purpose of the present appeal, it probably isn't necessary, we respectfully suggest, for the court to decide the matter in any event. And having said that, and given your Lordship's questions, it's probably sensible if I were to outline what I see as the 2 rival analyses. The first analysis is as set out in paragraph 271 of the judge's judgment, which your Lordships will find in the core bundle at page 190. I had originally planned to summarise it myself, what our position was, but on reflection, paragraph 271 summarises it far better than I ever could, and indeed it sets out the basis of the judgment which is being appealed. 271, HP2 says that those profits are themselves trust property, being the traceable proceeds of the Hyde Park Hotel sold to Kambula Madeira in breach of trust. I accept that in the absence of any defence of bona fide purchase for value in relation to the acquisition by the Kambula entities, the profits received from the on-sale of the Hyde Park hotels are themselves trust property, in which HP2's existing beneficial interest continued. Pausing there, I think that conclusion itself is uncontroversial, and reference is made to Foskett and McGowan. In these circumstances, as against Mr. Ruhan, those proceeds stand in the same position as the interests in the hotels did before them. It is well settled that a director who acquires the company's property in breach of fiduciary duty holds that property on trust for the company. Reference to J.J. Harrison. As Lord Justice Chadwick explained, this trusteeship is described as a constructive trusteeship. Is what is referred to as a Type 1 constructive trust because it arises by reason of the pre-existing fiduciary duty owed by HP2. If that is true of the hotels themselves, then I accept that is also true of their traceable proceeds in Mr. Ruhan's hands. But in short, therefore, under this first potential analysis, the judge, on the basis of J.J. Harrison, amongst others, found that following the self-deal stage at self-deal at stage 2, Kambula Madeira held the hotels on a Type 1 constructive trust for HP2. And then after the on-sales at stage 3, it similarly held the traceable proceeds or profits on constructive trust for HP2. In other words, what was in the Kambula Madeira bank account at the time of the dissipation, stage 4, were the traceable proceeds from the hotels. And my Lord, those findings under this first analysis found their way into the order at page 96 of the core bundle, which your Lordships will find behind tab 6. We did look at this previously, but in a slightly different context. And I would invite your lordships to look at the declarations. So Kambula Madeira 1, Kambula Madeira in entering into the BSA, that's the business sale agreement at stage 2 by which by which HP2 sold to Kambula Madeira. So Kambula Madeira in entering into the BSA and acquiring rights thereunder was acting as Mr. Ruhan's nominee. So that's the self-deal at stage 2. 2. Kambula Madeira in receiving and or disposing of the proceeds of the sale of CLGD following its sale to Minerva was acting as Mr. Ruhan's nominee. CLGD, that's the Lancaster Gate, Kambula Lancaster Gate SPV which is set up. So that's the first on sale at stage 3. Perhaps we can call that stage 3A. Then declaration 3. Kambula Madeira was acting as Mr. Ruhan's nominee in receiving and or disposing of 80% of the £115 million of dividends paid to it by CPHL following the sale of Kensington Hotels by CPHL to De Vere. My lords, in short, that's the second on sale, stage 3, stage 3B. The reference to CPHL, this is the joint venture with the Candids, but effectively this is the on sale of the Kensington Park Hotels. Yeah. Then 4, the beneficial interest of Mr. Ruhan in the rights and assets held for him by Kambula Madeira as his nominee, as referred to at paragraphs 1 to 3 above, was subject to constructive trust in favour of HP2. So that's all of the above stages. So your lordships will see what was found is that there was a constructive trust not only at 3A and 3B in terms of the proceeds of sale of the hotels. The judge actually found at an earlier stage. And to complete the picture, paragraph 5, in negotiating and entering into the agreement which comprised the Geneva settlement, Mr. Stevens and Phoenix were acting as Mr. Ruhan's nominees, such that any assets and rights acquired by Phoenix under those agreements were to be received and held for Mr. Ruhan. And that in fact took place in 2016. So Mr. Stevens was implicated in declarations even as late as 2016. My lords, as we say, the above declarations were all made pursuant to the first analysis. And as mentioned yesterday, the correctness of paragraph 271 had never been challenged. And certainly none of the above declarations is subject to this appeal. My lord, that's the first analysis. And as I say, that was the analysis found by the judge and not appealed. The second analysis is as per the discussions with your lordship yesterday. In other words, that following the self-deal at stage 2, Kambula Madeira did not hold the hotels on trusts. This brings in the rescission points your lordships were raising there yesterday. But that following the on sale, stage 3, the proceeds or profits made by Kambula Madeira as Mr. Ruhan's nominee were held on constructive trust. In other words, what was in the Kambula Madeira bank account at the time of the dissipation was not traceable proceeds from the hotels, it was nevertheless trust property which belonged to HP2. My lords, as I said a few moments ago, for the purposes of our argument, for the purpose of this appeal, it doesn't matter which analysis is correct. What is important to us is that on either analysis, what was in Kambula Madeira's account at stage 3 was held under a constructive trust and was therefore our property. That is the key. How we get there whether it's via the hotels having been held on trust in the interim or not, doesn't really matter. My Lords, having considered the position overnight, while we respectfully recognise the force in some of the arguments raised yesterday in terms of the second analysis, particularly in relation to rescission, which was not raised before the judge at the trial, and has never been raised as part of this appeal, our primary position therefore remains that the correct analysis is the former, as found by the judge, or at least it shouldn't be interfered with, because it's not subject to the appeal. But as we say, it may not matter, and it may not be necessary for the court to decide, because neither analysis, what was in Kambula's account at the time of dissipation, was trust property held for the benefit of HP2. My Lord, one may say that's sitting on the fence, but I hope that clarifies our position. Stage 3 is the important one. How we get there doesn't matter, and our primary position is that we actually stand by what the judge said.
Thank you very much.
My Lords, my second point is to return to our key point on loss. We say, given the above being that at stage 3, whatever's in the account is held on trust, it's a very simple case. On either analysis, at stage 3, Kambula Madeira, as Mr. Ruhan's nominee, held £94.5 million on constructive trust for HP2. As identified yesterday and accepted by my learned friend, we had a proprietary entitlement to that £94.5 million. It was our property. Importantly, Mr. Ruhan had custodial responsibilities, a custodial duty in relation to that property, in relation to that £94.5 million. Primarily, Mr. Ruhan ought to have given it to HP2, or at least retained it to its order. However, in breach of his custodial duty, Mr. Ruhan did not give it to HP2 or even retain it, and instead he spent it to his own ends. My Lord, we can put it very simply. Immediately before the spending, HP2 had property. It had £94.5 million. Immediately after the spending, it did not. It had zero. In short, Mr. Ruhan spending the money to his own ends in breach of his custodial duty. By doing that, Mr. Ruhan caused HP2 to suffer a loss of £94.5 million. Now, my Lord, that brings me back to my learned friend's submissions on the single transaction or separate and distinct point. We say effectively the inquiry as to loss starts and finishes as I've just described. It's as simple as that. We had £94.5 million and then we didn't. Mr. Stevens, the second defendant, wishes to avoid this obvious cause of action and this obvious loss by arguing that one should not consider that simple claim in isolation. When assessing equitable compensation, you generally compare the actual position with the counterfactual position as to what would have happened if the fiduciary had complied with his or her duties. In the present case, HP2's claim is straightforward. As I said, at stage 3, Mr. Ruhan had £94.5 million in his account, which he held on trust for HP2. But in breach of his duty, he did not give it to HP2 or even retain it, he simply spent it. So comparing the actual position with the counterfactual, the actual position is HP2 had nothing. The counterfactual is that in compliance with his custodial duty, Mr. Ruhan would either have given the £94.5 million to HP2, or at the very least, he would have retained it to his order. So HP2 would have had £94.5 million. So that's straightforward. The actual HP2 is 0. The counterfactual HP2 would have had £94.5 million. That's straightforward. The loss is 94.5. The question the judge asked himself, however, appears at page 194. It's at paragraph 278. And given how the appeal has been put, it's worth going through paragraph 278 as to the question the judge did identify for himself. And of course, under the subheading, can HP2 claim compensation for loss on the basis that it is entitled to be put into the position it would have been had the Hyde Park hotels been acquired and sold on by Kambula Madeira, and Mr. Ruhan had then accounted to HP2 for the profit. 278, I noted when considering the claim for unlawful means conspiracy, HP2 had advanced a single cause of action in conspiracy, embracing both the acquisition of the Hyde Park hotels from HP2 and their subsequent disposal and use, with the result that the but-for causation test had to be applied by reference to the position in which Mr. Ruhan had never acquired the Hyde Park hotels. But what is the position if HP2 has more than one cause of action for breach of fiduciary duty against Mr. Ruhan? One relating to Mr. Ruhan's acquisition of the Hyde Park Hotel. Well, pausing there, Mr. Ruhan's acquisition, that's the stage 2. That's Kambula as his nominee buying. So one relating to Mr. Ruhan's acquisition of the Hyde Park Hotels, brackets, by the Kambula transaction, stage 2. And another or others relating to the failure to account for or the use of the profits made from their disposal. And Mr. Stevens had dishonestly assisted both breaches. In that scenario, would it be open to HP2 to sue on the second breach, the disposal, dissipation, without bringing the first, the original sale to Kambula, into account when arriving at the counterfactual position? Your Lordships have seen these paragraphs, and you'll see at paragraph 279, Judge started by saying this is an issue which has occasionally troubled the court in other contexts. And reference was made to the Brown and KMR services case, which of course in itself internally referred to the Bartlett case. In 281, we have the Charles Villeneuve case. In 282, it continues with the Hallsbury passage. And in 283, while these authorities are not concerned with the position in which the first breach occasions the gain, which is then lost by the second, they do support a principle that a claimant with more than one cause of action, some of which cause loss and some gains to the claimant, is ordinarily permitted to advance its claim and is but for causation case only by reference to those breaches which caused loss. My Lords, in 283, the judge is expressly acknowledging that these cases go to something different from the precise issue in the present case. The cases which we were looking at on Tuesday and yesterday, Bartlett and Brown, and the references in Underhill and other authorities, they go to the case where there are distinct breaches, and some of those breaches make losses, and some of those breaches make gains. And the question in those situations is, can the beneficiary or principal sue just on the losses, or must the gains also be taken into account? So there should be a set-off for the gains. Now that sort of analysis doesn't directly fit in the present case, as the judge himself accepts it. This is the case where an earlier breach was the occasion, or was an earlier step, as was set in 283. Now, My Lords, the breach HP2 claimed for was the dissipation of profits, the caused a loss of £94.5 million. No one is suggesting, not the judge in his judgment or the appellants in this appeal, that Mr. Ruhan committed some earlier breach which resulted in a gain for HP2, which ought to be taken into account. It's not that sort of case. The sort of cases we're looking at is should there be a set-off. It's difficult,
isn't it? I mean, your case is that the fiduciary breach, as you call it, the stage early one, whatever it is, causes gains to be made which do accrue to HP2 because they're held on constructive trust for it. That's your whole case.
well, the actual breach was the self-dealing.
Yes.
But no one's suggesting there should be some sort of set-off as such. What the judge was concerned with, the question...
The self-dealing gives the opportunity to develop
Lord, yes.
hotels and make a profit, which is a profit which you say belongs to you, so you've made a gain from that. And the breach at stage 3 is that you are deprived of that, isn't it?
My Lord, yes. In the sort of case we were discussing, for example, in Bartlett, there was a loss of X, but a few years earlier there had been a specific quantifiable gain. It was a question of setting the two off. The judges
they were, in a way, more obviously, one might think, two distinct transactions because they were years apart and related to different properties. That's a factual difference.
Well, the judge himself said, he says in 279, this issue has troubled the court in other contexts. And in 283, he expressly says, while his authority is not concerned with the position in which the first breach occasions the gain. So that was the concern the judge had, as opposed to considering a precise set-off. Well, nothing so much turns on that. But
I was just querying your submission that first breach didn't cause any gains to accrue to HP2, and I had thought it was your case that they did. That it did.
Well, my Lord, the point I'm making is that the test the judge was setting for himself wasn't precisely the same. He wasn't looking at a set-off of X against Y. He was looking at the question of effectively the counterfactual. What counterfactual? Because everything was started off by the self-deal. Should that be taken into account by comparing what actually happened in the counterfactual? Lord, I think nothing turns on that precisely. I'm simply pointing out that the test which the judge set himself is slightly different as he accepts it, but it was analogous. My Lord, the short point which we make is that what the judge concluded by applying those cases by analogy is that he quite obviously reached the correct conclusion. The earlier breach and the later breach might have been part of the same scheme. The scheme is a very general world, but they were clearly not part of a single transaction, quite clearly. Lord,
just before you leave this territory, my Lord has explored what is obviously a central issue. Just going off at a tangent for a moment, we understand that where there's been a breach of duty such as you allege, the principal has a choice of claiming an account of profits or claiming compensation.
well, yes.
Is there any case in which a principal has claimed an account of profits and claimed compensation in respect of an asset which it can only claim at all by claiming an account of profits?
Lord, I'm not aware of any such authority.
I mean, it could be that the answer is you have to choose. You either claim an account of profits or you claim compensation. You can't combine them.
Well, I'm not aware of any case where the issue has come up for consideration. As a matter of principle, there ought to be the principal, as your lordship rightly says, has a right of election between account or equitable compensation as against the fiduciary, and similarly as against the an assistant, for example, or a third party.
Can we leave the assistant out of it for a moment? Because first question is there a claim for compensation against the fiduciary, against Mr. Ruhan? And you're saying you can claim the account of profits and then could have claimed compensation for his disposing of the profits. Is there anything in the authorities to say that that's right?
My lord, I'm not sure if there is. Perhaps I can just turn my back. We're not aware of any authorities along those. We deal with the question either way. My lords, in terms of the judge's conclusion that this was not part of a single transaction, effectively, and that he could consider the claim in isolation, which, as with authorities, is the general rule. The general rule is if one has a cause of action, one can bring it, and one applies usual principles. The idea of bringing in a separate earlier breach or separate earlier claim is an exception which one only brings in these rather unique circumstances where they can said to be not separate and distinct and a single transaction. And the judge, we say, reached the right conclusion, obviously so. There were three reasons which he particularly outlined, and my learned friend discussed with your lordships yesterday. And perhaps we could briefly look at those. The first at 286, I did touch on this briefly yesterday, so I won't labour the point. This is the adoption point. My learned friend suggested in the case of an adoption, it doesn't mean that the adopted breach should somehow be ignored in determining whether the breach has suffered a loss. But, my lords, we say with respect that misses the point. The point the judge was making was in a situation like this, where there have been several stages of wrongdoing, if the beneficiary adopts an earlier wrongdoing, it was arguable, and the judge uses the word, it could be argued, that no claim for dishonest assistance could arise at that stage. But of course, if the same dishonest assistant also assisted in relation to a later breach, he would be liable for that breach. This merely demonstrates that the breaches can be separate and distinct. The mere fact that you can have two stages and different outcomes. At 287, this is the second dishonest assistant point.
Sorry, just sticking with my theme a moment. I'm trying to work out the relationship between claiming profits and claiming compensation. So far as the fiduciary is concerned, you adopt his making of the profit on this thesis. And on that basis, you claim the profit?
Yes.
You can't both claim the profit and claim his lost the profit. I mean, that would give you double counting. You can't say, well, he made a profit of 90-something million, we'll claim it. And we'll have 90 million for losing it.
One has to consider at what stage. Mr. Ruhan made the profit at stage 3, and £94.5 million. He gets 94.5 million as a profit, and we claim the profit.
And therefore, aside from any trust question, you say that money he is accountable to us for that money.
Well, yes, so at this stage, at stage 3, two things. One, there is cash, and we have a proprietary claim to that.
But forget the proprietary claim.
And we have a claim, a personal claim for an account as against Mr. Ruhan.
And it doesn't matter whether he loses, whether he spends the profit or not. You've still got the claim to the profit.
Well, yes.
Yeah.
Then at stage 4, the money disappears. So, my lord, imagine at this stage, HP2 had discovered the cash in the account. At that stage, it says it's our money, we're a proprietary claim. Mr. Ruhan has absolutely no answer, and so he has to hand the money over. But instead, he dissipates it. In fact, with the assistance of someone, that's by the by at this stage, and he dissipates it. Now, my lord, if my learned friends are right, it would follow that we had £94.5 million, and then suddenly we didn't, and there is no remedy for that, because the money has now gone. It's a separate and distinct breach.
But you can't have both claims. You can't both have a claim for 90-something million by way of accounted profits and a claim for 90-something million for compensation. That would give you 180-something million, which can't be right.
Well, with respect, no, that's not how we put our case. Well, it can't be right, we say, that if Mr. Ruhan does nothing and sits there and then or simply hands the money over, we have our money. But if he says, I'm going to I will now pass the money away, I will spend it in a casino, that he can then say, well, I'm sorry, but there's no remedy for you.
So which claim do you have? Do you have a claim from the accounted profits, or do you have a claim for compensation, or do you have both?
Lord, at the earliest stage we have the accounted profits, but at the stage of after the loss, there's a separate breach. We have our compensation claim against Mr. Stevens.
You mean you no longer have a claim for accounted profits?
My lord, I understand your lordship's previous query about whether there's been a case where there'd been both. But my lord, at this stage, we certainly rely on the loss, the compensation.
Well, can we just think that one through for a moment? You start with a claim for 90-something million. You say you keep that claim, presumably.
Well, yes.
So when the property has been dissipated, you've still got the claim. You've still got a claim for 90-something million. You can't have another claim for another 90-something million.
You couldn't recover twice. Well, with respect, we can. But one often has, this is not a case of being joint and several, but one often has a case where you have claims for the same, rising out of the same matters. And if you recover under one, you have to credit another case. It's not limited to joint and several cases. We certainly accept that we can't recover the money twice, but we do say that we have two distinct claims. At stage 3, Mr. Ruhan's made the profit, and we've got our personal claim for him for the profit. Stage 4, he then dissipates, and he's caused us a loss because it's our property, which he has not given to us, and in fact, contrary to his custodial duty, has given it away. So that's a separate loss. And in relation to that, we go against Mr. Stevens because he was actively assisting in that. Your Lordship saw seen the material yesterday. Now, if we were to recover any money from one, we couldn't recover in full from one, we couldn't recover from the other. But given there are two distinct acts there, my Lord, it is possible to claim an account against for one stage and compensation for another. And my lord, if that weren't the case, it would lead to an absurd result. As I say, one can imagine the situation where we demand the money back from Mr. Ruhan. And if he complies with his duty, he parts with the money. But if he doesn't comply with his duty and spends it, he can say to us, my friend, you've got no remedy. And that can't be right.
Well, no, you can't say that because he has to account for his profit. The mere fact he's spent his profit doesn't affect his liability to account for it.
My lord, yes, but there's a separate breach by the failure of the custodial duty. And so we could claim on that basis against Mr. Stevens for the breach of custodial, or assisting the breach of the custodial duty. I hope that goes some way to answering your lordship's question. Well, perhaps I can turn my back. Well, I was going through the 3 points raised by the judge. The second was what I described as the second dishonest assistant point. This is a good point. We say if there are different stages of wrongdoing, and at one stage the fiduciary is dishonestly assisted by X, and at a later stage he is in the scheme he is dishonestly assisted by Y, then both would be liable. That must be the case. That's uncontroversial, would be assumed. Again, this shows the discrete and distinct nature of the breaches. My then friend pointed out that if in fact X just assisted at an earlier stage, he or she might also be liable for whatever happened later on one reading of the authorities. We're not sure if that's correct, and we reserve our position in relation to that. But in any event, it doesn't apply to this case. Mr. Stevens dishonestly assisted at the earlier stage, Cambulo acquisition stage, but he also dishonestly assisted at the later stage, stage 4. But that's by the by. The key point here is the mere fact that you could have two dishonest assistants helps demonstrate the discrete nature. This isn't a single transaction. So that was another reason which reinforced the judge's view.
These reasons don't go to whether there was a single transaction. They are concerned with whether there are separate causes of action, which, as you agreed yesterday, is a prior and
it's sufficient, but
step.
my lord, I do accept that. And the third point I can take briefly, it's what the judge described as, well, with as a known recipient. The judge was simply saying that if a party receives money and then is a known recipient and pays the money away, that would amount to a breach. And if the dishonest assistant assisted that, he or she would be liable. And it couldn't be any different if the recipient, rather than being an independent party, was a nominee. But again, it's just ways of demonstrating that there are, I agree with my Lord Ismail's analysis, showing there are separate causes of action. But we do say that they do tend to illuminate and demonstrate that they are discrete.
I mean, regardless of whether you could have made a claim at stage 4 against Mr. Ruhan for failing to account to you as a claim for equitable compensation, that's not the claim you have in fact got judgment for. The only claim you've got judgment for against Mr. Ruhan is the liability to account, as you showed us earlier.
Lord, yes. Lord, yes. Effectively, that's the stage 3, failure to account. Yeah. Lord, yes. Lord, in any event, this part of Learning Friends' attack on the judgment comes down to whether the general rule should apply, and HP2 can sue for its loss in the usual way, just looking at what it has lost, or whether the appellant can show that the earlier breaches are really part of the single transaction in some way. And for the reasons which I've said, we say it's obvious they are not. And my Lord, even if one might say this was broadly one scheme, it's a very general word, and the defendants had a goal to defraud HP2. Many friends described that yesterday as the general scheme. The idea was for Mr. Ruhan to get the money. That's something extremely wide. That scheme was undoubtedly made up of numerous transactions. And we say it cannot be realistically said that those numerous transactions, in reality, should be considered a single transaction. The portfolio argument simply doesn't work here. Well, Lord, perhaps I can give an example. Going back to the Bartlett case, that was a case, the Lordships will recall, where it was a professional trustee, and in breach of duty, they made an investment which met some gains. So that was rather fortuitous, I think it was described as being. But they also, using by the same breach, effectively, same all policies, suffered a loss. And one can see the portfolio approach where you have effectively a trustee of some sort carrying out duties. If it transpires they're in breach of duty, one can see that in certain circumstances, depending on the actual case, you can't just take the rough without the smooth. So that's why we have the portfolio situation. So, for example, someone, a trustee, acts outside his or her powers in a number of matters, one has to consider them as a whole. We can see why that might work for professional trustees or investors. That can't work in the context of a fraud. This is a fraudulent scheme by Mr. Ruhan, which was dishonestly assisted by Mr. Stevens. The way that Mr. Justice Brighton dealt with the Bartlett case was that he sort of stood back and felt that justice of the case demanded it. He didn't go into great much detail. And one can see that with a professional trustee or an investment type situation. But if you've got a fraudulent scheme, and imagine a fraudulent scheme that involves many transactions or many transactions within it, and some of them bring in gains and some bring in losses, it can't be right to say that the fraudsters can take the benefit. And that is best demonstrated by going back to my example of the fraudsters being caught with the money in the account.
But the trouble with that is that the law has distinguished between the liability of the fiduciary to account for profit and the liability of the assister to account for profit. If you lumped it all together, then it would make sense to say, look, the assister and the fiduciary are liable for the same profit, but they're not.
No, Lord, it's in terms of analysing whether it's a single transaction or should be considered.
But when you sort of look behind to the policy as you're doing, and you're saying, look, this is a dishonest scheme, why should one sympathise with the dishonest assister? The fact is he's not liable for the profit made by the fiduciary.
Well, look, we accept that, but this is demonstrated by the example I gave earlier. So we have various dishonest stages, and the money ends up in the account. And Mr. Ruhan finds out that HP2 is aware and wishes to make and demands the money back. Now, part of the scheme was always for Mr. Ruhan to have the money. Now, if Mr. Stevens does nothing and doesn't assist, then Mr. Ruhan pays the money over. But he completes the scheme. He successfully completes the scheme by assisting Mr. Ruhan to move the money. Lord, it can't be right. With with professional trustees and with investments that go up and down, one can see that effectively one should give credit for some previous work. So in fact, in the Bartlett case, the transaction which resulted in a credit came earlier in time. Now, and obviously when the trustee later made a loss, he didn't look back and think, well, I've got a credit, and therefore I can take further risks. But if that were to apply to fraudsters, the fraudsters say, well, we've made a gain earlier, therefore now we've got the money in our account. HP2 want the money back, they've got a proprietary entitlement. But because there's been an earlier gain, we can pay it away because effectively we have a credit.
Now, doesn't your submission that, as you said a moment ago, part of the scheme was always for Mr. Ruhan to have the money for himself, cast some light on whether it's a single or two separate transactions? This was, as you said, a single scheme. Your separate transaction analysis almost seems to treat Mr. Ruhan as if he suddenly finds some money in the account, namely the profits, and he's got to decide what to do with it. And he makes a decision, oh, that's very nice, I'll keep it for myself. But that's a very artificial way of looking at it. That was never even a question he was going to ask himself. It was always, as you say, money which was headed for his benefit and not yours.
Well, I certainly understand your Lordship's point, but this is a scheme which went on for many years, indeed way beyond 2008 with Mr. Stephen's assistance. But even the relevant period, there were numerous transactions and numerous stages. I've simplified matters. It's set out in Mr. Justice Foxton's judgment.
Well, it took a long time to do it, and the mechanics were no doubt complicated, but in essence it was a scheme to purchase the hotels for a nominee, develop them, and sell them on at a profit which he would keep for himself. It's as simple as that, really, isn't it, when you strip away the detail?
Well, that's the scheme, and we accept that in very general terms. But it can't be right that if within that scheme there are various transactions, and some make gains and some make losses, each one gives rise to a cause of action, gives rise to a claim. But it can't be right that if the fraudsters say, well, in fact, we've made some gains here, we've made a gain of £100 million odd, if we ought to hand this over because we've got a custodial duty for this money. But in fact, because we've actually made this gain ourselves, therefore, if we dissipate it, we've got a credit. Well, that really can't work. That would be an absurd result with respect. It works in an investment when you've got professional trustees, because it's obviously not done deliberately. But it can't be right that fraudsters can pick and can effectively say, well, because I was successful in making money, it was all in breach, it was also self-dealing, and I took advantage of the opportunity. And I've made £100 million. Now I should hand it over because it's a proprietary entitlement, but I've got a credit effectively. I can just pay it away, and no one can get me because I've got a credit effectively, because you have to take the rough with the smooth.
Well, you say it works for professional trustees because they're investments, but although we can't perhaps spell this out of Mr. Justice Brightman's reasoning in Bartlett, I would suggest that what might be going on there is that there is a decision in breach of trust to engage in a high-risk, high-return policy from which it is almost inevitable that there will be some transactions which pay off and do generate the high returns. And the question then is whether it is fair to enable the beneficiary to claim where all the investments don't pay off without giving credit for the ones where they do.
My Lord, yes, that was pretty much...
And that's nothing to do with the fact that it's professional trustees or
My Lord,
it's
yes.
to do with investments. It's the fact that there's a single breach of trust which generates some profits and some losses.
Well, Lord, I accept that. I rephrase, I use the word professional, but non-fraudulent. In a non-fraudulent situation, and of course, it's a matter of degree. In the Bartlett case, there were these two high-risk investments, several years apart, but there was the same strategy. Your Lordship will recall the Brown case, whereas Mr. Lord Justice Stuart Smith sympathised with the Bartlett view, and Your Lordship saw the view of Lord Justice Hobhouse, who said that was, although that case could be explained on its facts, on their case, which involved it's a similar background, but comparing different years. He said that each cause of action should be considered separately, and it wasn't right to apply a portfolio. It depends on the facts of that particular case. So, my Lord, I understand Your Lordship's point, and rather than saying professional, I simply say non-fraudulent. But my Lord, where there is a fraud, it can't be right that where a gain is made, the fraudsters can say, well, I've made a gain here, therefore I can give the money away because effectively I've got a credit. It's simply, that can't work in a fraudulent situation. And my Lord,
why is that? You accept the question is single transaction or not, and if that is the question, why should it matter whether the conduct of the fiduciary is fraudulent or not? It's either a single transaction or it isn't it?
Well, my Lord, to say a single transaction that's not a statutory term. That's just a summary. The general rule was set out by Mr. Justice Brightman in the Bartlett case and repeated by Lord Justice Hobhouse. And the general rule is that every separate and distinct cause of action you can sue, and without taking into account other matters. But there are these exceptions where the matters are effectively can't be seen as separate and distinct. The other side of the same coin. The single transaction was simply, from recollection, that was a reference in Underhill as opposed to in any of the authorities. It's just a shorthand.
If we take Mr. Ruhan, for example, leave aside questions of dishonest assistance, does it make any difference to his liability so far as equitable compensation is concerned, whether he was acting honestly or dishonestly? Suppose he thought he was perfectly entitled to do what he was doing. Nothing wrong with it. He paid the market price to get the hotels and was making a profit he thought he was entitled to do. But he's wrong about that because he's a fiduciary, but he can nevertheless be perfectly honest. Does it make any difference to his liability in terms of analysing whether it's separate and distinct or whether it's a single transaction?
My Lord,
credit for which has to be brought into account that he's acting dishonestly, and if so, why does that make a difference?
My Lord, it does. Perhaps I can go back to the Brown case, which wasn't in the bundle. I handed out a hard copy yesterday. It's the case the judge relied on in his judgment, and it refers to Bartlett. We handed up some All England reports.
Yep.
And it was the judgment of Lord Justice Hobhouse. Perhaps I can just...
Page 640.
My Lord, yes. This is again not fraudulent trustees, and this case, of course, expressly considered Bartlett.
Well, it's quite interesting because on page 640, Lord Justice Hobhouse makes a deliberate point that the cause of action is a legal one, not dependent on any equitable or restitutionary principle. Albeit on the next page he does go on to consider Bartlett. So I'm not
Yes.
quite sure, and I'd welcome your assistance on what point he's making about it not being an equitable cause of action on the first page. That seems to have
I'm afraid I can't assist.
some significance for him.
My Lord, I'm afraid I can't assist with what was in Lord Justice Hobhouse's mind. I'm not sure at that point if anything turns on that. But what is right, we say, is the analysis is set out just above E. The correct analysis is there have been a series of separate breaches of contract on the part of defendants. In each year, it was the contractual duty of the defendant to advise Mr. Brown on his allocations the following year. The plaintiff, therefore, has an independent separate cause of action in respect of each year. His cause of action in respect of an earlier year might become time-barred when that in respect of a later year was not. The cause of action in respect of the underwriting year 1990 is on a different contract to that covering the previous years. Mr. Brown is entitled to assume that of each distinct cause of action. Each cause of action gives right to a right in law to recover the damages which the plaintiff has suffered by reason of the breach. And then it's the reference which your Lordship made. The cause of action is a legal one arising under contract, not dependent upon equitable principles. It was an action, not an action for an account. Although there's an element of repetition, it was not a continuing breach. Just above H, accordingly, the function of the court in the present case in its sole function is to find and award the plaintiff the damages which the plaintiff has proved that he has suffered as a result of respectively the three distinct breaches of contract. The judge may have thought that he was doing some high justice, but who is to know whether that in fact was the case? How far back does one go? It is perfectly possible, indeed probable, there had been some proper advice given in respective years earlier than 86. Should the judge have investigated whether that was in fact the case and whether the plaintiff thereby suffered losses or gains? Where a plaintiff has distinct legal cause of action, he is entitled to choose in respect of which cause of action he sues. Other distinct cause of action are relevant, just as is irrelevant in the present action, whether the plaintiff made a profit or loss in underwriting in 1991. And at C, at 641, Lord Stuart Smith, with whom I have the misfortune to disagree on this point, has referred to the case of Bartlett, in which Mr. Justice Brightman allowed a set-off. That was an action by the beneficiaries of a trust against the trustee. The trust property was 99% of the shares in the company. The trustee was in breach of its duty. So Mr. Justice Brightman observed that the part of the profits from the company's successful speculation had been used to finance the unsuccessful speculation, adding, I think it would be unjust to deprive the trustee of this element of salvage. The principle applied by Mr. Brightman arose from the context of that particular case. It cannot, in my judgment, properly apply to the legal remedies being enforced in the present case. Indeed, the principle applicable to such cases is summarised in the recently published Horsbury, in terms which are scarcely helpful to defendants, where a trustee is liable in respect of distinct breaches of trust, one of which resulted in a loss and the other in a gain. He is not entitled to set off the gain against the loss, but is liable for the whole loss occasioned by the one breach, while the estate is entitled to the whole gain realised by the other. Your Lordship asked me whether the fact that Mr. Ruhan was fraudulent is of relevance. Well, my Lord, if Mr. Justice Brightman had been determining the case or considering this question and applying the hat he was wearing in the Bartlett case, he could see the connection between those cases and felt it was just that the benefit, credit should be given for a similar strategic investment from the one which was being sued. Lord, in the present case, we accept there was a scheme, a fraudulent scheme, that comprised many different transactions. And the question is, what's it just to do? Is it just to just look at the proprietary claim which HP2 had in relation to the monies which came in, £94.5 million, sitting in an account, and to which it had a proprietary claim? Or can Mr. Stevens or Mr. Ruhan, for various purposes, can they say, well, no, you have to look back. We were involved in the earlier stages. We effectively made the gains. We did work to increase the value. That being the case, we can now, even though you have a proprietary claim, even though there's a custodial duty, we can just dissipate that without any consequence because we made the gains earlier. That would be to effectively ignore property rights. Lord, it's a question of what's ultimately...
Well, it's not that you can dissipate them with no consequences, because you are always liable to account. The question is whether, by way of equitable compensation, the beneficiary can claim for losses suffered, which is a different question. But he doesn't get off scot-free, Mr. Ruhan, by dissipating and saying, "Oh well, I made a gain in the first place," which comes into account. He's got to account. All he can say is, "Well, looking at what I did, you haven't actually suffered any loss overall, even though you've got me banged to rights on liability to account for profits."
Lord, as against Mr. Ruhan, we had an account of profits, and so that's right. But in terms of dishonest assistant, a loss occurs when our property is taken with his assistance. It was fraudulently taken, and he dishonestly assisted me.
Okay, thank you.
My Lord, if my learned friends are right, the result is that on their case, Mr. Stevens, I apologise to keep going to my example, but it really does bring it into focus. Mr. Ruhan has the money in his account. HP2 are knocking on his door, asking for the money back. Mr. Ruhan calls Mr. Stevens, says, "Will you help me dissipate this money?" Now, on Mr. Stevens' own case, he says that he can do that without consequence. Part of the dishonest scheme is that he's supposed to be assisting Mr. Ruhan. So Mr. Ruhan rings up Mr. Stevens and says, "Will you assist me disposing of it, getting rid of this money so it can't be found?" Mr. Stevens assists him and helps the dissipation of our trust property. He, in fact, successfully completes the fraudulent scheme. And he gets off scot-free. So we're not talking about his assistance at the previous stage, which helped with the self deal, which then was the platform to enable the property to increase in value and be developed and make a substantial profit for Mr. Ruhan. The money is there. We have the profits. We have an account against right from account to Mr. Ruhan, but we also have the cash there in an account. Mr. Ruhan is under a custodial duty. We've looked at this in buyers. It's clear. It's a custodial duty to hand that money over, or at least retain it to our order. He picks up the phone. "Mr. Stevens, will you help me move this money?" Mr. Stevens has a fresh act of assistance, and that money is gone. My Lord, on D2's case, second defendant's case, he can do that without consequence for himself.
Does that take you back to, I've never known whether it's Gwemb or Gwemby, but whichever it is.
My Lord, I don't know. I've been calling it Gwembe, but...
you're probably right, Mr. Pickering.
I don't know. I have two additional points. They're brief. I know counsel often says that, but I'm going to stick to it. The appellants refer to this. They say it's a similar case, and that if we are right in our case...
So we're on Gwemby?
My Lord, yes.
Yes, quite.
Unless I can assist with the...
No, that makes sense.
The appellants say that Gwembe is a similar case to ours, and that if we are right in our case, the court in Gwembe would have awarded equitable compensation to the claimant in that case. Lord, 2 points. The first is that the case was lost at first instance on equitable compensation and on appeal based on burden of proof. Nothing, and what was found on the facts of that case. The company's argument was based on the burden of proof. Perhaps we could look at it.
I think it's tab 31.
Great. If I could ask your lordship to look at paragraph 147 first of all, of the judgment. At 147, what Lord Justice Mummery said was, when determining whether any compensation, if so, how much compensation should be paid for loss claimed to have been caused by actionable non-disclosure, the court is not precluded by authority or principle for considering what would have happened if the material facts had been disclosed. If the commission of the wrong has not caused loss to the company, why should the company be entitled to elect to recover compensation as distinct from rescinding the transaction and stripping the director of the unauthorised profits made by him? There is no sufficient causal link between the non-disclosure of interest by Mr. Koshy and the loss suffered by the company, if it is probable that, even if he had made the required disclosure of his interest in the transactions, the company would nevertheless have entered into it. In our judgment, a director is not legally responsible for loss which the company would probably have suffered, even if the director had complied with the fiduciary dealing rules on disclosure of interest. But Lord, we then have at 151 what the company's submissions were. It was argued on behalf of the company that Mr. Justice Reimer was wrong to hold there was no evidence that the company had suffered any loss as a result of Mr. Koshy's breach of duty, as it was impossible to assess what would have happened if Mr. Koshy had made proper disclosure of all relevant facts to the board of the company or to the shareholders. And the next paragraph is important, we say. Mr. Thompson, that's counsel for the company, submitted that the judge should have concluded that the company was entitled to compensation to put it back in the position that it was in prior to Mr. Koshy's breach of duty, and should have either quantified it or directed an inquiry. The position is that traditional trust rules apply, so the only relevant question is whether the breach of duty caused by Mr. Koshy caused the misapplication of the company's money in the sense that it would not have happened. I don't think I need to go to the rest of that paragraph. But if you could turn to 159, in our judgment, Lord, apologies, I ought to go back to 152. I apologise. Beneath A, this is the company's argument. What was being submitted? The law should presume that disclosure of a material matter was not disclosed would have made a difference. It should be left to the wrongdoing fiduciary to prove otherwise. The burden of proof is on Mr. Koshy, who was not discharged by invitation to speculate about what would have happened. Mr. Justice Reimer should have proceeded on the basis that the transactions would not have been done and that all the loss arising from the company's entry into the transactions was recoverable from Mr. Koshy. Alternatively, if the burden of proof was on the company, the judge was wrong to hold that it had not been discharged. He should have concluded that with proper disclosure, the pipeline loan transaction would not have been entered into. It was also contended that the causation issues would be simplified by identifying breach of fiduciary duty other than non-disclosure. For example, breach of duty of loyalty and of the duty to avoid conflicts of interest and duty of Mr. Koshy's actions in committing the company to the transactions at all. But for the breach of those duties, the transactions would not have happened at all, and the company would not have suffered loss in the venture. So those were the company's submissions. But I can skip straight to 159. And what Lord Justice Murray concluded was this. In our judgment, Mr. Justice Reimer was entitled to refuse to order equitable compensation on the factual basis that he was not satisfied that loss had been caused to the company as a result of the breaches of duty by Mr. Koshy. The crux of Mr. Koshy's wrongdoing was non-disclosure of his personal interest in the pipeline loan transactions and the unauthorised profit made by him from the transactions. The appropriate remedy for non-disclosure is to make him account to the company for that profit. It's not appropriate if the company so elected to require him to compensate the company for loss suffered in the venture, when the probabilities are, as the judge on the evidence found them to be, that disclosure by Mr. Koshy of his interests would have made no difference to what the company would have done. But Lord, it's a negative point. My learned friends say that in Gwembe, the judge would have ordered equitable compensation. It wasn't ruled out as a matter of principle. It was simply found as a matter of causation. The judge found as a matter of causation. It wouldn't have happened. It would have happened anyway. Even if Mr. Koshy had disclosed, the company was in financial difficulty, it would have suffered no loss, and therefore it would have authorised. That's what he found about the probabilities. So that case was dismissed, and that dismissal was upheld on appeal on the purely the factual basis. Well, the second point to make about Gwembe is that the constructive trust argument was not raised at any time. It simply wasn't argued.
Sorry, which constructive trust argument? You mean your stage 2 argument?
Well,
which...
my lord, in Gwembe, the director made a side deal involving a loan, and he personally, or his company, made profits. It wasn't suggested that there was a trust in relation to that case. It simply wasn't argued.
Sorry, it wasn't suggested that there was a trust in relation to what?
To the profits, to the money which he made arising out of.
I mean, just so you understand.
So it wasn't suggested that the sort of arguments we're running today weren't raised. So the short point, my lord, is that my learned friends rely on Gwembe to say that if we are right, Gwembe would have been decided differently. Well, that's wrong for two reasons. One, Gwembe, in terms of equitable compensation, was dismissed on a factual basis. And secondly, the sort of arguments that we're running today weren't run there.
It looks from the head as though there was an argument about constructive trust, though what precisely the argument was, I haven't figured out.
The argument which we run today wasn't posed.
No, can I just explore it for a moment?
Well, yes.
I have to say, when I think about this case, I'm a bit puzzled in one respect. But we get a reference to trusts in the section dealing with limitation, I suppose, sort of beginning at paragraph 117.
Yes.
And we are here concerned, aren't we, with the profits that Mr. Koshy had made.
Well, yes.
And they go through, and at paragraph 119, they say, it's clear in our view that any trust imposed on Mr. Koshy is a class 2 trust. So he, in the context, LASCO has entered into transactions with GVDC, or whatever it's called, giving Mr. Koshy the opportunity to make profits by buying whatever it is on advantageous terms. And what the Court of Appeal says is, well, if there's a trust there, it's a class 2 trust. Now, if one took that seriously, in Paragon terms, that would be a trust that was not an institutional trust. And yet, if we think about our case, on the face of it, there's a great similarity. On the basis that there was no rescission at the start, what you say is, well, look, that really doesn't matter because the no profit, no conflict rules mean that the director is accountable for the profit he's received. That's like Mr. Koshy making his profit. You say, well, that's an institutional trust. I have to say, I understand why you say that. But this might suggest it's not an institutional trust because it's a type 2 trust.
My Lord, the FHR case has changed that. This case was 2004, I think, 2004, yes. Certainly FHR makes it clear it's an institutional trust. And that, your Lordship's heard my two analyses this morning. What is uncontroversial between both sides of this courtroom is that the profits received at stage 3 in our case form an institutional trust and proprietary entitlement.
And I suspect you're right about that. I mean, in effect, you're saying that this is wrong. It's not a Class 2 trust. And then one slightly wonders about quite how useful Paragon is.
My Lord, in terms of type 2, well, my Lord, yes, quite. I think the correct analysis is that type 1 is type 1, but within type 2, it's slightly difficult. There are certainly those which do involve institutional trusts and maybe some situations which don't. So it is possibly of questionable use.
As I understand it, the difference between, I hesitate to say this because I'm going to end up getting it wrong, but the difference between type 1 and type 2 isn't just that one's institutional and the other isn't. It's about what circumstances bring them into being in the first place.
My Lord, yes.
So the second type isn't not institutional. It's one that arises only when as it were, the bad thing happens.
My Lord, precisely. That distinction remains.
And that distinction, in that sense, what's said here makes sense, doesn't it?
Lord, yes. That the position in terms of institutional trust.
Wembley.
My Lord, yes. My Lord, yes. But precisely. But the position has been clarified in FHR.
I can't remember whether in FHR they refer to Paragon at all. They might well not. But anyway, you say, well, it's still useful to draw a type 1, type 2 distinction, but possibly not for the bit where Lord Justice Millett says it isn't a trust at all.
My Lord, yes. What is not in dispute in this case is that the profits received by Mr. Ruhan for institutional trust, it's our property. In Gwembe, which is obviously pre-FHR, that point wasn't run. So there was this debate which we see in the section 3 in paragraph 119, but there was no institutional trust argument run. So basically, Gwembe isn't useful. We say, my own friends say it's useful to show why we are wrong. We say, well, one, it was dealt with on the facts, and two, it was dealt with pre-FHR when they didn't raise the point which we raise. We rely on the fact that what was taken was our property, and that argument wasn't run, couldn't have been run in 2004.
I mean, clearly it was dealt with on facts, but so far as equitable compensation is concerned, it also stands for a principle, doesn't it? Which is that it is for the claimant, the beneficiary, seeking equitable compensation to prove causation so that it is relevant to look at what would have happened if there had been no breach, i.e. if there had been proper disclosure, and that is contrasted with the position if you're simply claiming an account, where that's an irrelevant consideration. And if we think about that in terms of our case, at any rate at stage 2, your stage 2, where there was non-disclosure of the interest in Cambulo, which Mr. Ruhan had, the judge's finding that he can't say what would have happened if there had been disclosure, means in equitable compensation terms that it was you who had failed to discharge any burden upon you. Is that right? And if so, does that take us anywhere? Maybe it doesn't.
My lord, it is right. We didn't run that argument. It's not that we didn't discharge the burden. We didn't seek to do so as the judge.
Yeah, well, same result, but yes.
If time had stopped, if we were suing in relation to stage 2, the non-disclosure. So HP2 sells to Cambulo Madeira, and Mr. Ruhan didn't disclose his interest. In relation to that, we would have certain remedies as against Mr. Ruhan, but not equitable compensation. So your lordship is absolutely right.
Yeah, now I'm not sure if it
and in terms
has
of
any significance for the case, but it's just trying to get it clear in my mind.
My lord, yes. But we say that where we bring the case in relation to effectively against Mr. Stevens is at stages 3 and 4. After stage 3, the profits come in. It's a simple case. We now have an institutional trust. It's our property. And then
I follow that. Thank you.
And so the causation argument there is very simple, my lord.
Yep.
Lord, those were my 2 brief points on Grenbay, possibly not quite as brief. I apologise for that. I then move on to the final point of round 1. So I'll make this, I hesitate to say I'm going to make it quickly, but I hope I will. It's the additional point as our respondents' notice. And it really is additional. We don't need to rely on it. We say it simply reinforces our position. I just wish to refer to 2 of the authorities. First of all, the first case, which is at tab 44. And in particular, page 2360. Your lordships will be familiar with this case indeed. My lord Newey was in this case. The basic principles which come from these line of authorities.
I mean, it is a very odd case, this one. It's a very odd case on the particular facts, but...
My lord, it was. What comes out is some what we say is useful reasoning and law principles, and effectively it considers 2 types of compensation. In the context of compensation, 2 types: substitutive compensation and reparation. Substitutive one puts back what's been. I'm going to say what's been taken. It's not quite as simple as that, but the value, effectively. And its reparation, one looks at what one, if, for example, there's been want of care, effectively consequential loss on that basis. And the significance between the 2 is that if it's substitutive loss, one just simply looks at the value of what's been lost and replaces it. If it's reparative, one has a more stringent causation test. So if we can show that it's substitutive loss, the question of counterfactuals simply just falls away, effectively. My Lord, 16, page 2364, and this is the judgment of Lord Justice David Richards. In my judgment, this approach involves a narrow reading of compensation. There's not an accountable authority. Equitable compensation is apt to include a payment made to restore a claimant the value of assets or funds removed without authority by a trustee or other fiduciary, such as a director. It may also include reparation for losses suffered by the claimant, such as in this case any tax penalties and interest resulting from the payment of the unauthorised remuneration. but it is not restricted to reparation for losses, as the judge appears to have held by his adoption of Mr. Thompson's binary distinction between loss-based and gains-based remedies. The position is stated as an underhill. Equity recognises two types of compensation claim against trustees, which will be termed substituted performance claims and reparation claims. Substitute performance claims are claims for money payments as a substitute for performance of the trustee's obligation to produce trust assets in specie when called upon to do so. Claims of this sort are apposite when trust property has been misapplied in an unauthorised transaction, and the amount claimed is the objective value of the property which the trustee should be able to produce. Reparation claims are claims for a money payment to make good the damage caused by a breach of trust, and the amount claimed is measured by reference to the actual loss sustained by the beneficiaries. Claims of this sort are often brought where trustees have carelessly mismanaged trust property, but they lie more generally where a trustee has harmed his beneficiaries by committing a breach of duty. And the final paragraph, I've referred to as paragraph 18. In the same work, the means by which these two types of equitable compensation are given through an accounting process are explained. As discussed below, there are two types of compensatory claimants which lie against trustees: substituted performance claims and reparation claims. These are mediated through proceedings for an account in different ways. In the case of a substituted performance claim, where the trustees have made an unauthorised distribution of trust property or used trust funds to purchase an authorised investment, and the court will not permit the trustees to enter the distribution or expenditure into the accounts as an outgoing, because it will not permit the trustees to say they acted in breach of duty. Instead, they will be treated as though they have spent their own money and kept the trust assets intact. The accounts will be falsified to delete the unauthorised outgoing, and the trustee will be ordered to produce relevant trust property in specie or pay money substitute out of their own pockets. Reparation claims are brought into the scheme of the accounts a different way. The loss claims by the beneficiaries is translated into an accounting item by surcharging the trustees with the amount of the loss as if they'd already received the amount of the beneficiaries. They must then pay this sum into the trust funds out of their own pockets. My Lord, that sets out the basic principles of the difference between the two. Perhaps I can turn to Davis and Ford.
I mean, how it played out here was in particular circumstances where there had been an order such that a claim for equitable compensation had gone, was it? And you had to work
It
out.
turned on interpretation of the order.
Yes.
That's right. Yes. The other case to which I'd refer is Davis and Ford. It's gone to the Court of Appeal, but in fact it's the first instance judgment of quantum which I'd refer for the point I wish to make. It's a T52, tab 52. I invite the court to please turn to paragraph 106, which is at page 2747. I'm not proposing to take your lordships to the Court of Appeal. The judgment was generally upheld.
I think the Court of Appeal addresses specifically, doesn't it, whether this part of the analysis is correct. But anyway, let's see what Mr. Holland says.
Lord, yes. To my mind, what these authorities show is that equitable compensation for breach of fiduciary duty, which involve the misappropriation of existing trust property, is generally assessed on a substituted basis. In such instances, the aim is to restore to the trust what has wrongfully been paid away, and is not open to the trustee or fiduciary who has been in breach to argue the counterfactual. That is, the trust property would have been lost or paid away even if he or she had not been in breach. Reference is made to AIB, First and the Auden Mackenzie Patel case. However, in cases of breach of trust or fiduciary duty which do not involve the misappropriation of existing trust property, such as breach of duty of loyalty and those which involve the trustee in making profits at the expense of the trust or the use of information opportunities available to the trustee in that capacity, or breach of duty of skill and care resulting in loss to the trust, equitable compensation will be assessed on a reparative basis. This requires the court to determine what would have happened but for the breach of fiduciary duty. The breaching trustee or fiduciary is entitled to argue the counterfactual. The court can be asked to consider how the principal or company would have acted if the trustee or fiduciary had not acted in breach of duty. Reference made to Gwembe. This seems to me to be a principled approach as with the latter type of breach. The court is not seeking to replace property or assets which already belong to the trust or company and were wrongfully diverted, but rather to assess sums or profits which the trust or company did not make because the opportunity to make the profit was wrongfully diverted away. I will take your lordship's, if I may, to the Court of Appeal, but pausing there, we say that we question slightly what's said in paragraph 107. In that case, the deputy judge distinguished between existing property and other monies which came in, including breach of duty of loyalty. Well, with respect to the deputy judge, what should have been considered is whether it was actual property of the company, whether it was existing or not. So if, for example, there's a breach of duty of loyalty, which results in there being an institutional trust, paying that away is the same thing as paying away money which was been in the trust for years. And indeed, I note from, if your lordships have my learned friend's skeleton to hand, it's at page 27 of the core bundle, it exists. At page paragraph 38 is a footnote in the reference to Gwembe. In Koshi, unlike in the present case, the profits were not made through unauthorised dealings with company property.
Sorry, I'm looking at the wrong place, but where did you tell me to go, which I have gone?
My lord, it's footnote 8.
Footnote 8, sorry, yes. Yeah.
In Koshi, unlike in the present case, the profits were not made through unauthorised dealings with company property, at least not directly. It's difficult to see why this should be a legally relevant point of distinction. In both types of case, the profits regarded as being acquired for the benefit of the principal and are held by the fiduciary and constructive trust of the principal. Lord, we think that there is no distinction. It's institutional. So, in terms of substitutive and reparative, we say the deputy judge with respect got it wrong, in that the key is whether it was property of the company. So yes, existing property, but that shouldn't exclude property which becomes property of the company. So for example, where you have profits made in breach of the no conflict rule, it becomes the property of the company. If that is then paid away, that's the same. Of course, what's completely different is where you have some sort of want of care case. One can see that's a reparative case. But if it's about the misappropriation of company property, it doesn't really matter whether it was existing or pre-existing or not. Well, that's the point we make there.
So, are you saying that Mr. Holland got it right or got it wrong? I'm a bit confused.
Mostly right, but wrong in terms of where he draws the dividing line.
So which bit do I cross out?
Well, my lord, paragraph 106, we say that's right.
Yeah.
The Deputy Judge said equitable compensation for breach of fiduciary duty which involved the misappropriation of existing trust property
Yeah, I
is
follow that.
generally assessed on a subject basis. And that's right. 107, in cases of breach of trust or fiduciary duty which do not involve the misappropriation of existing trust property, but then he says, his examples, we say, aren't all right. Breach the duty of loyalty, well, it depends what he means by that. But if it's a sort of case, as in, for example, on our case on the second analysis, whereby profits are made but held on an institutional trust, that becomes the property of the company. It's an institutional trust.
Can you remind me, what was the breach or property at issue here? What was Mr. Holland concerned with?
In this case, there were numerous different claims. There was some straight property which had been taken. There's a diversion of business opportunity from recollection.
Yeah, I mean, he concludes that compensation falls to be assessed on a reparative basis.
Well, yes.
And does that conclusion necessarily rest on 107?
My Lord, I don't think so. But perhaps I could, to answer my Lord Justice Nail's questions, where I think the Deputy Judge was wrong. For example, in 1.7, he gives examples. Breach the duty as a skill, etc. One can see that's clearly reparative. But we say, while the judge was right in principle, say that the property of the company, if there's a misappropriation of property of the company, it's substitutive. If it's not the property of the company, it's reparative. But the examples he gave, he included in the second category, breach the duty of loyalty. Well, certain breach the duty of loyalty, such as profits made arising out of a breach of the no conflict rule, are institutional, as that is company property.
So does your point come to this, that you say at stage 3 there is an institutional trust so that the profits are HP2's property,
Yes.
and therefore, for the reasons you've already given, it's a misappropriation of existing trust property case for which substitutive equitable compensation is available. And does that depend on whether it is right, as you've already addressed us on, to look at the position at stages 3 and 4 separately from what preceded it, or on the other hand, whether one looks at all stages together, in which case it's a making profits at the expense of HP2 case, where Mr. Holland, at any rate, says it's a reparative approach. So in other words, I suppose I'm asking, what does this particular point add, other than more sophisticated analysis, to the essence of ground one which you've already addressed us on?
My Lord, if we fall into the reparative category, to use Deputy Judge's, to use the language used here, then the analysis which we've been discussing for the last couple of days applies. We have our claim. We say it's as simple as one looks at the loss at stage 4. My learned friend...
Yeah, I think we've got that point.
That's the reparative loss analysis. If we're in the substitutive loss position, then it's simply about putting the money back in. One doesn't need to consider counterfactuals at all.
Yes.
It actually reinforces. My worst case scenario on my additional point is that everything I've said before applies. But if we're right on the substitutive point, it actually short circuits everything. Shortcuts everything. Well, just to complete the picture, I probably ought to take the court to the Court of Appeal, which appears at at tab 53. The relevant section appears at 2866 from paragraph 125 onwards.
So is it,
Page 2866. There's a subheading, round F, what is the correct basis of assessment of equitable compensation against Mr. Marks? Judge, paragraph 127 says something which I suspect is uncontroversial. This is an area of the law which is unfortunately bedeviled by confusing terminology and a lack of general agreement on how the underlying concept should be analysed and labelled. We then have reference to Underhill. And then further at 127, further references. At 128, reference is made to the AIB decision. And reference is made to the leading judgments of Lord Toulson and Lord Reed. And perhaps I can invite the court to read from 128 down to the conclusion of paragraph 132. So just about a page, a couple of pages.
Just help me. There's reference to what Lord Newberger said in FHR.
Oh, yes.
And that must be earlier in the judgment.
Lord 86.
86. Yes,
it does start at 84, in fact. My Lord,
To begin with, forgive me, can I ask you about 131?
my Lord, yes.
In 131, it ends with saying, in such cases, it seems to me the right approach is that the principal may seek a substitutive remedy in respect of existing trust property which is misapplied or on account of profits. If he elects not to seek an account, he should be confined to reparative compensation, reparative remedy, and so on. Might it be said that, on your case, they missed a trick because the equitable compensation could have included both the loss and the loss of the profits? But your case is that you can have equitable compensation for not being given the profits the agent earned.
Well, yes. I think that might be. Lord, Lord, I think the short answer is yes. That may answer some of the previous concerns. But, my Lord, in terms of how this impacts upon the Deputy Judge's judgment, which sets out the analysis of 106 to 108, it was upheld as generally impeccable, but 131 is indeed the key there. Your Lordships have my submission that this is we say this should be treated as a substitutive case.
But I'm afraid I haven't thought through all the detail of this, but in the sentence to which my Lord was taking you a moment ago, Sir Lancelot Henderson, I think it is, says that you can have a substitutive remedy in respect of an account of profits. And I'm not quite sure that's consistent with what Mr. Holland had said.
Well, possibly not, but not in a material way. And the general principle set out in Underhill and in First, which we agree is a unique case, indeed in Patel, and it's a distinction between substitutive and reparative. The significance being whether we look at a counterfactual at all. As I've submitted, if I'm wrong, and this is a reparative case, we're back to where we were. But this is a potential short circuit. If the court were to accept my first analysis, as the judge held, that this was a trust claim all the way through, and therefore what was in the account at the time of the dissipation with the traceable proceeds would undoubtedly be in existing property territory, undoubtedly. So in fact, as the judge below held it, it was a traceable proceeds which Mr. Stevens assisted in the dissipation. In that case, I'd undoubtedly be in paragraph 106. If the court were minded to go down the paragraph 107, the alternative analysis, albeit it's not appealed, it's still a trust, and we say it makes no difference. And in that case, we say the deputy judge, with respect, was wrong, and it should have treated it as existing property.
Can we just look at paragraph 126 of
Well, yes.
the Court of Appeal in Davis and Ford, which make clear that it is talking about two main types of compensation claims against trustees,
Well, yes.
and then in the quotation from Underhill says that substitutive claims are a substitute for performance of the trustee's obligation to produce trust assets in specie when called upon to do so.
Well, yes.
Now that raises in my mind at any rate a question about whether the position of a dishonest assistant is different. Why should a dishonest assistant who has not received trust property in the way that the fiduciary has be liable on a substitutive as distinct from reparative basis? And following on from that, is there any case where a dishonest assistant has been held liable on a substitutive basis?
My Lord, in answer to the first question, one, with all accessory liability cases, takes in two stages. First of all, as against the principal, Mr. Ruhan, we say here, classically fits into the description. He has misappropriated company property, and his primary obligation is to restore or produce the trust assets in specie. So he has to produce them. That has caused a loss, and therefore if he doesn't produce the assets, the actual assets, we have an equitable compensation claim as against him, because he has caused a loss equal to the in specie property which he hasn't been able to produce. Now, if Mr. Stevens or someone has assisted in relation to that, it ought to be exactly the same liability.
Well, we know from Novoship, which very soon you're coming on to, I imagine, that that's not always the case.
Well, in relation to an account of profits, yes, but not in terms of equitable compensation.
Well, yes.
This is possibly, this is probably for Novoship, I'm coming on to that.
Yeah, okay.
Very soon.
But on the second question, is there any case where the accessory dishonest assistant has been held liable on a substituted basis?
Well, Lord, perhaps after lunch I hope that I can finish my submissions, possibly before lunch, possibly not. But over lunch, possibly I can see it answered.
Well, thank you very much. Yes.
My Lord, perhaps thanks to Mr. Hodge, I can answer that question now. It's in our skeleton argument, Ray Bell's indenture. Perhaps I could start by going to our skeleton. It's a paragraph 53. Perhaps I can invite the court to read
Sorry for not having picked it up.
paragraph 53. And as a matter of convenience, if your lordships could continue reading paragraphs 55 and 56, they deal with an academic opinion on that issue.
Yeah, thank you very much.
Well, so we say that there is support in not only Bell's indenture, but also in Underhill and the Professors Elliott and Mitchell. My lords, to summarise...
Sorry, can I just think, I bet actually if I read all this stuff again, I'd be absolutely clear the answer, but what is the relationship between the claim against the fiduciary and the claim against the dishonest assister? If you opt for compensation against the fiduciary, then it's sort of straightforward. you get compensation against the dishonest assister. If you opt for an account of profits against the fiduciary, well, you can get an account of profits against the dishonest assister, but only for his own profits. Is there an example of getting an account of profits against the fiduciary and compensation from the dishonest assister?
Lord, again, I'll have to think about that. Your Lordship will be aware that often it's the case that a claim will be brought only against a dishonest assistant. Often the fiduciary has gone to liquidation or disappeared. So it's certainly not the case that one needs to have a separate established.
No, I follow that. But supposing it were the case that for one reason or another there were no claim for compensation against the fiduciary, either because there just couldn't be or because the option had been taken to go from an account of profits, is there an example of the dishonest assister being held liable for compensation?
Lord, again, perhaps I can turn my
Yes. Well, don't worry, come back to it later.
Perhaps yes. My Lords, if I can just very briefly then summarise ground one. We say our case can be put in the simplest of terms. Through his fraud, Mr. Ruhan undoubtedly obtained a secret profit. That secret profit was realised in the form of cash in a bank account. That cash was undoubtedly cash held on constructive trust for HP2 as beneficiary. Mr. Ruhan then dissipated that cash and did so with the result as the direct and dishonest assistance of Mr. Stevens. And as a result of that dissipation, assisted by Mr. Stevens, HP2 lost its cash, it lost its property, it suffered a very real loss. The defendants, or the defendant, we say, seeks to put an artificial spin on matters, and they seek to effectively to ignore property rights. We had property to which we were entitled, it's now gone. If this had been Mr. Stevens' first involvement, at this stage, there'd be no doubt that he'd be liable for the loss. He can't be in a better position just because he also dishonestly assisted in the original fraud. Lord, we say it's a very simple case, despite having taken over a day to set out my position. My Lords, perhaps I can then move on to ground two, and the novership. There are 3 points which we can take relatively shortly. The first point, it's what I will summarise as the dog that didn't bark point, the point which my Lord Ismail's raised my learned friend yesterday. The present appeal is an equitable compensation case against a dishonest assistant. The classic statement in relation to equitable compensation against a dishonest assistant appears in Grippo Torres and is followed in Cassio. And perhaps just pausing here, if your Lordships could turn to the judgment, page 197, paragraph 291. Page 197, paragraph 291. And your Lordship will see a useful summary of the classic statements in Grippo Torres and Cassio Computer. So the present appeal is equitable compensation against a dishonest assistant. Novership, however, is an account of profits case against a dishonest assistant, and it came after Grippo Torres and Cassio. And novership, as your Lordships have seen, we've taken through it in some detail, they expressly considered Grippo Torres and Cassio, and indeed expressly cited it with approval. That case was concerned with an account of profits. It did not need to and did not grapple with the issue of equitable compensation. It really is the dog that didn't bite. My first point, in short, the law in relation to equitable compensation as against a dishonest assistant remains as set out in Grupo and Casio, and we would invite the court to follow those cases. The case law being summarised succinctly in paragraph 291 of the judgment. Well, Lord, the second point follows on from that, and it's Group 7, another case to which my learned friend, which we refer to our skeleton, my learned friend referred to it yesterday. This is at tab 49, page 2458. In short, that this court should follow Grupo Casio is reinforced by Group 7, where a similar argument as that being put today was heard by the Court of Appeal and rejected. Lords, perhaps I can just briefly summarise the facts of the case. Fraudsters obtained about 100 million euros by way of fraud. The fraudsters then purported to loan it to a company controlled by one of the fraudsters. And they did that by transferring the money to a client account of a firm of solicitors where it was held for the benefit of this fraudster company. The fraudster then instructed the solicitor to make various payments, including a payment of £170,000 to an accountant who had facilitated the fraud. It was alleged that the accountant had assisted breaches of duty by the fraudster in his capacity as director of the company. And at first instance, the judge dismissed the claims against the accountant, applying the dishonesty test. He said the dishonesty test wasn't met. It went to appeal, and it's right to say that much of the appeal focused on the issue of dishonesty. But for the present purposes, there's a useful passage between paragraphs 108 to 110. You can find those at 2505. The learned friend did take you to these yesterday. Perhaps I can invite the court to read 108 to 110.
Yes.
Lord, the key passages there, first of all, it's the passage just above F of page 177. The statements, so just below F, the statements in novership arose in a different context of a claim for an account of profits who do not assist the appellants in the present circumstances. My Lord, it was expressly considered whether novership should apply or not in a similar case, and it was held at a different context. And also of notice 3, this turned on the particular facts of that case, and even if contrary to our view there was some substance in the appellant's advocacy of some stricter causation, there needed to be a direct link between the assistance and the loss as opposed to the breach of trust and loss, it would not avail in the facts of this case. Well, that's similar to this case. I don't need to refer your lordships to it, but in paragraph 293, the judge considered that. And was certain that there was that the stricter test of causation in the present case was met in any event. I probably ought to take you to paragraph 293 in that context of the judgment. It's page 198.
You mean, so 293 of Miss Justice Foxton's judgment?
My Lord, yes.
Yes.
Lord, at this point, I should also deal briefly with my learned friends, what we describe as their alternative argument. And I invite, our position is summarised in our skeleton at paragraph 70 to 73. The Lordships have the HP2 skeleton argument to hand. This is the argument that about real and effective cause, and we summarise in paragraph 70 what the defendants say, what Mr. Stevens says. 95 of his skeleton, it cannot seriously be suggested that Mr. Ruhan would have accounted HP2 for the profits but for Mr. Stevens' continued assistance. The argument is that no compensation should be payable because Mr. Ruhan's misappropriation was not causally attributable to Mr. Stevens in a real or effective sense. It is likely Mr. Ruhan would have gone ahead and regardless, even if the second defendant had not helped him. And we say that's obviously misconceived. The beneficiary doesn't need to show that the dishonest assistance involvement was directly causative. What's relevant is the loss caused by the breach of fiduciary duty. My Lord, the final point which I'd make in relation to novership, my learned friend's point where he says that if we are right, it's akin to making a desistant liable for the profits of the fiduciary. Well, my Lord, that all depends on the nature of the wrong.
Sorry, I wasn't keeping up. Could you just give me the proposition again?
My Lord, yes. One of my learned friend's complaints about what we say the position is and what the judge found in his judgment was that it's akin to making a dishonest assistant liable for the profits of the fiduciary. In our case, Mr. Ruhan made a profit of £94.5 million, and we're seeking equitable compensation from Mr. Stevens for £94.5 million. My learned friend's complaint of the judgment is that makes the dishonest assistant akin to being liable for Mr. Ruhan's profits in the circumstances where in novoship it was thought that the assistant should be liable only for his or her own profits. Well, my lord, the answer to that is it all depends on the nature of the wrong. There are different types of breach of fiduciary duty which can be assisted. In the present case, Mr. Ruhan made his secret profit. That secret profit was realised in the form of cash in a bank account, cash which was held on trust for HP2. Mr. Ruhan then dissipated that cash with the direct dishonest assistance of Mr. Stevens. So, as a result of that breach, the breach of the custodial duty, that duty, as assisted by Mr. Stevens, that dissipation assisted by Stevens, HP2 lost its cash. In this case, yes, the two do coincide. That's because Mr. Stevens helped Mr. Ruhan dissipate the profits from the bank account via the mood facility. He assisted in Mr. Ruhan breaching his custodial duty. He assisted at this stage, so of course it happens to coincide. But one can imagine other breaches where equitable compensation would arise if it arose in a different sum. So, for example, at an earlier stage, as we discussed, if we had sought equitable compensation against Mr. Stevens at the time of the self-deal, there would have been no claim. So, my learned friend complains that in this case, the result is that Mr. Stevens pays equitable compensation for the fiduciary's profits, which is not what novoship wanted. Well, no, that's not what novoship said. Is that on an account of profits, he or she should be liable for his own gains and not the fiduciary's. But when one considers equitable compensation a loss, it depends what the loss is. In some cases, there'll be no loss, so no equitable compensation claim. Sometimes it will be different. But if it's a breach of the custodial duty, and the custodial duty in relation to what happens to be the profits, then of course it will coincide. So there's nothing absurd about that. It merely depends on the particular circumstances of the breach. Perhaps I can continue with that. My friend Mr. Hodges, just an example. In our case, Mr. Ruhan receives £100 million odd of profits. So there's an account of profits against him for £100 million. Imagine Mr. Stevens assisted in paying £20 million of it. So £80 million stays in the account. In relation to that, there's a breach of custodial duty. And Mr. Stevens would be liable only for the what's been dissipated. The fallacy with respect to my own friend's argument is it happens to be the breach of custodial duty for all of the profits, but it could have been for a lesser sum. It's merely a coincidence. Well, quite simply, we say that the judge's reasoning in relation to novoship, which expressly considered, and his decision to follow Gruppatoris and Cassio was an impeccable decision with which, with respect, this court should not interfere. My lords, I move on to ground 3. I note the time. I suspect I probably can't quite finish before 1 o'clock. I'm in your Lordship's hands as we'd like to press on. Or...
I think make a start.
My Lord, yes.
Then we'll see where we get to.
My Lord, yes.
I'm not suggesting, Mr. Pickering, you should sit down finally at 1 o'clock, even if you're sort of on the point of doing so, because there are one or two loose ends anyway, aren't there, from this morning?
My Lord, yes. I might be able to finish, but
yes.
Subject to those loose ends. We'll see. Well, first of all, perhaps I can start with the what my learned friend described as the constitutional point. Westdeutsche is undoubtedly the final word. It is. It's the final word on primary liability. It says nothing, absolutely nothing, about accessory liability. In that case and the predecessors, there was simply wasn't before the court the question of dishonest assistance or any other form of accessory liability. So there is no final word from the Supreme and the court. So, my Lord, there is no constitutional bar, as my old friend suggested. What we do have are powerful judgments at first instance and from the Privy Council in the Central Bank of Ecuador, and other judgments from, and they all go one way. Well, Lord, perhaps we could start with the Merino case. It's at tab 47. Lord, the relevant part starts at 2433, paragraph 27. It's a useful review, and Mrs. Justice Cockerell reviewed all the authorities. She took on board all the points which have been made it and formed the view that she did. 27. The final question is out of interest, whether it should be simple or compound. Mr. Amura contends that interest should only be recoverable on a simple basis because the order of equitable compensation is analogous to common law damages. Mr. Amura says the starting point is to be found in Libertarian, where Lord Millett describes equitable compensation as akin to compensatory damages, and the judgment of Lord Reed in AIB, where he described equitable compensation as isomorphic with an award of damages. Reliance is also placed in the judgment of Mr. Peter Smith in the Zambia case, where he found that the court had no power to award compound interest for dishonest assistance because there was no fiduciary element. Mr. Amora acknowledges the thrust of the case, the Central Bank of Ecuador, where by reference to the judgment of the Court of Appeal in Noviship, the Privy Council concluded the refusal in that case to distinguish between the liability and dishonest assistance of fiduciary and non-fiduciary assister was equally applicable to discretion to award compound interest. He submits, however, that discretion is really applicable where money has been received or retained by fraud, or where it has been withheld or misapplied by a trustee, or anyone else in a fiduciary position. This, it is submitted, is not a case where Mr. Amura received or retained money by fraud or procured or assisted Mr. Marino and Mr. Besso to apply those assets. In such a case, the analogy with damages should be found to be appropriate and simple interest would follow. The judge goes on. I'll start by dealing with the materials which I referred. But 32 is really the key. The authorities support the view that whatever the very real analogies between equitable compensation and damages, the two are in fact distinct. As Lord Reed says in AIB, that liability for breach of trust is not generally the same as liability and damages for tort or breach of contract. Structural similarities do not, however, entail that the relevant rules are identical, as in mathematics, isomorphism is not the same as equality. Compound interest is most clearly applicable to cases where money has been obtained and retained by fraud or misapplied by a fiduciary. However, there is discretion toward compound interest against a non-fiduciary dishonest assistant. That is clear from Noviship, where the liability of both fiduciary and non-fiduciary to the remedy of an account of profits was settled. It is noteworthy that the court at 75 also stated a liability to make good loss and the liability to account for profits follow from the premise the defendant is held liable to account as if he were truly a trustee to the claimant. And the nature of liability, as it seems to us, is that knowing a recipient of dishonest assistant has in principle the responsibility of an express trustee. The admittedly non-binding endorsement of that approach in the Central Bank of Ecuador, the board considers that this is in principle correct, and the same approach must govern the discretion toward compound interest. There is in this connection no satisfactory reason why those who dishonestly receive and retain or procure or assist the fiduciary to misapply the fiduciary assets should be in any different position from the fiduciary who actually misapplies the assets. This is perhaps particularly obvious in the case of those who dishonestly procured or assisted the fiduciary to misapply the assets. So there are a number of things there. The position is stronger for a dishonest assistant than perhaps a named recipient. And the position is even stronger in a case of equitable compensation. Now, my Lord, going back to the relief against the fiduciary, it can be an account of profits or it can be equitable compensation. The justification for an account of profits is to make sure the fiduciary doesn't benefit from his or her breach. It's not supposed to be penal, but it's to make sure that the fiduciary doesn't benefit from his or her position. Equitable compensation is to deal with the loss suffered by the beneficiary. Now, I don't have to argue, and the Lordship don't have to decide what the position would be if I was seeking account of profits from Mr. Stevens. Or in fact, I probably ought to argue that too, but that's not the principal position. Our case here is equitable compensation. Equitable compensation is to look at the loss which HP2 has suffered. Now, as against Mr. Ruhan, there is no doubt, there's no appeal, there should be compound interest. For reasons which are well established, it fell squarely within the limb of monies obtained and as a result of fraud. And again, there are justifications as to why the fraudster should have to pay on a compound basis. It's not penal, that's clear, but it's just a generous interpretation to make. There's a presumption one way, in one of two ways. It's either presumed that if the beneficiary had the money, which he or she's been deprived, there's a presumption that he or she would have invested it as wisely as possible. The alternative presumption, the other side of the same coin, is that in fact the dishonest or the fraudulent trustee has the money. There's a presumption that he or she has used it most wisely. So the rationale behind awarding compound interest against the fraudulent trustee, not penal, it's just generous presumptions to do the very best to put the beneficiary in the position that he or she would have been in. Now, in equitable compensation, the purpose is to put the beneficiary in the position they would have been. And so if the loss as against the fiduciary is such that because of the nature of the fraud, there should be these very generous presumptions. That's the measure of loss. And the liability of the distal assistant should be precisely the same. So we say it makes absolute sense. There is absolutely no constitutional bar because only primary liability has been determined. There is no case at the highest level on that, but there's only one direction for the cases who have considered it, and there are others which we set out in our skeleton argument in addition to the Privy Council case and Mrs. Justice Cotterell's case, and we said I don't propose to take you to them, but they are referred in particular in paragraph 76 of our skeleton argument, and we invite the court to look at those in due course. But the policy reasons are good, given that the purpose is not penal, it's to compensate the beneficiary. And if the circumstances are such that the fiduciary should pay compound interest, to give full compensation, it must follow that the accessory should have to pay the same. Well, I've surprised myself 3 minutes to 1.
Well, I'm not binding you not to come back on anything else you think of over the short adjournment.
My Lord, perhaps I can take your Lordship's up on that. I think I've finished my submissions, but there may be some points I should come back to, given various questions.
And evidently, we're very much on schedule to finish this afternoon, so that's reassuring. Say 2 o'clock.